people can handle their forfeiture aspects on their own. You do not need an attorney to do so. And the letter you get from the county indicates that you can show up with counsel or without. My recommendation to people is always it's better to have a lawyer present for two reasons. One, as I said earlier, I have a working relationship with the county and Mr. Campanelli's office, so as well as Brian does, Griffin does as well. So when we call, we tend to get, by no means do we get special favor, but Mr. Campanelli will listen to what we have to say, and I'm able to get him on the phone and talk to him about the specific person that I'm calling about. The second thing that's important that people don't realize, and it's really not explained to them, is oftentimes at retention hearings, when people are not represented by counsel, they're asked questions that can hurt them in the criminal case. And that's something that people who don't do this for a living wouldn't realize is a potential downside to showing up without a lawyer. For instance, when you're testifying at a retention hearing, oftentimes that person will admit to driving the vehicle that night. That's an element of driving while intoxicated that we often use as a defense in defending the criminal sides of things. So the district attorney's office has to prove operation of the vehicle. If someone who doesn't have a lawyer goes to a retention hearing and admits to operating the car that night, the district attorney's office can use that testimony in their criminal case. So having a lawyer at both proceedings, whether it's the same lawyer or two different lawyers, is only a benefit to the person trying to get his car back and trying to mitigate the damages of the criminal arrest as well.